Welcome to Crime Time Inc. My name is Alex, and I'm your host for today's episode. Episode 20 in our Charles Manson series. By April 1970, Buliosi was facing a prosecutor's nightmare. Despite having Susan Atkins' earlier grand jury testimony and statements that she had printed "pig" on the front door of the Tate house, and that Patricia Krenwinkel had written the words at the LaBianca residence, Buliosi couldn't use any of this as evidence. The deal made with Atkins rendered her testimony inadmissible, and handwriting experts told him it would be extremely difficult, if not impossible, to match the bloody writing with any printing samples. As evidence, those 13 blood-soaked letters appeared worthless. But Buliosi had an idea, a legal gamble that, if successful, could transform those bloody words into damning evidence. The Fifth Amendment protects against self-incrimination, but the Supreme Court had ruled this only applies to verbal statements. A defendant can't refuse to provide physical evidence like fingerprints or handwriting samples. Armed with this knowledge, Buliosi devised a brilliant strategy. At Sybil Brand Institute for Women, Susan Atkins is brought in and informed she has no constitutional right to refuse, no right to have an attorney present, and that her samples can be used as evidence against her. The deputy then tells her, "The word pig was printed in blood at the Tate residence. We want you to print the word pig." Without complaint, Atkins prints the word. Next, Leslie Van Houten is brought in and given the same instructions, but with different words. Helter Skelter, Death to Pigs, and Rise were printed in blood at the LaBianca residence. We want you to print those words. Van Houten complies. Then comes Patricia Krenwinkel. Same instructions, same request to print those words from the LaBianca crime scene. Krenwinkel refuses. Bugliosi's gamble had paid off. Krenwinkel's refusal could now be used as circumstantial evidence of her guilt. This was doubly important because until that moment, Bugliosi had absolutely no independent evidence corroborating witness Linda Kasabian's testimony about Krenwinkel's involvement in the LaBianca murders. Without corroboration, Krenwinkel would have been legally entitled to an acquittal on those charges. But the prosecution's challenges were far from over. One of the most puzzling pieces of evidence was a pair of eyeglasses found at the Tate murder scene. None of the victims wore glasses, suggesting they belonged to one of the killers. Yet none of the defendants, Tex Watson, Susan Atkins, Patricia Krenwinkel, or Linda Kasabian, wore glasses either. This was potentially devastating for the prosecution. The defense could argue that since the glasses didn't belong to any of the defendants, at least one killer was still at large, meaning the wrong people might be on trial. But sometimes crucial evidence comes from unexpected places. Roseanne Walker was a heavy-set black woman who had been incarcerated with Susan Atkins at Sybil Brand on drug charges. She operated as a walking commissary, selling candy, cigarettes, and makeup to other inmates. Only after 5 or 6 interviews with Buliosi did she recall a conversation that would crack the eyeglasses mystery wide open. One day, Walker and Atkins were listening to the radio when the newscaster mentioned the eyeglasses found at the Tate murder scene. Atkins laughed and said, "Wouldn't it be too much if they arrested the person the glasses belonged to when the only thing he was guilty of was losing his glasses?" When Walker suggested maybe the glasses did belong to the killer, Atkins replied, "That ain't the way it went down." With that simple statement, Atkins had inadvertently revealed that the glasses did not belong to any of the killers, neutralizing what could have been a devastating defense argument. The prosecution's case was built on a series of such small victories, often balanced by frustrating setbacks. Buliosi knew that to convict Manson, he needed to place the murder weapons in his possession before the killings. They knew from Danny DiCarlo, a straight Satan motorcycle gang member who had spent time with the family, that Manson had purchased about 200 feet of white 3-strand nylon rope, the same type used to tie victims Sharon Tate and Jay Sebring, at a surplus store in Santa Monica in June 1969. But when detectives finally interviewed the store owner 3.5 months after Bugliosi's initial request, he couldn't find a purchase order for the rope or confirm it was from his inventory. The attempts to trace the rope's manufacturer also failed, another dead end, but Buliosi wasn't ready to give up. He thought of Ruby Pearl, George Spahn's ranch manager. Remarkably, despite numerous police visits to Spahn Ranch, no one had interviewed Ruby. Bugliosi found her to be a fund of valuable information. Examining the Tate Sebring rope, she confirmed it looked like the rope Manson had. She also identified the leather thong found at the LaBianca residence as similar to ones Manson often wore, and noted that before the family arrived at Spahn, she had never seen buck knives there. But in summer 1969, suddenly it seemed everyone had one. Then there was Randy Starr, a movie stuntman specializing in fake hangings. He stated the Tate Sebring rope was identical to rope he'd once used to help Manson pull a vehicle from a creek bed. Even more importantly, Starr positively identified the .22 Longhorn revolver used in the murders because he had once owned it and had given it to Manson. But a crucial question remained: why bring 43 feet 8 inches of rope to the Tate residence? According to DiCarlo, Manson had told him in late July 1969 that establishment pigs ought to have their throats cut and be hung up by their feet to really throw the fear into people. The implication was chilling. The killers had likely brought the rope intending to hang their victims, a grotesque spectacle that thankfully never materialized. The prosecution faced other challenges. The wire cutters found in Manson's dune buggy were initially thought to be the ones used to cut the telephone lines at the Tate residence. But when Officer Dwayne Wolfer, LAPD's foremost expert on physical evidence, tested them, he concluded they couldn't have been the ones used, even after additional testing under conditions matching the night of the murders. There were some wins, though. In April 1970, Sergeant Lee returned to Spahn Ranch and found 23 more .22 caliber shell casings in a gully behind George Spahn's residence. Combined with 22 found in an earlier search, this gave them 45 shell casings, 15 of which were determined to have been fired from the Tate murder gun. This was crucial scientific evidence linking the murder weapon to Spahn Ranch, though the 4.5-month gap between searches opened the door for the defense to argue the evidence had been planted. Perhaps the most puzzling aspect of the case was the story of Linda Kasabian, the prosecution's star witness. While her testimony was crucial, her actions after the murders raised serious questions. After the LaBianca killings, Kasabian fled Spahn Ranch, but left behind her toddler daughter, Tanya. How could a mother leave her child in what she knew to be a den of killers? This contradiction threatened to undermine her credibility. When Buliosi asked her this question, Kasabian replied, "Something within me told me that Tanya would be all right, that nothing would happen to her, and that now was the time to leave. I knew I would come back and get her. I was just confident that she would be all right." Would a jury believe this explanation? Buliosi wasn't sure. Another major problem for the prosecution: they desperately needed third-party corroboration of Linda's story. For the Tate murders, they had Rudolph Weber, who had seen the suspects washing off blood near his home. But for the LaBianca night, they had no one. Despite extensive efforts, investigators couldn't locate any of the people who could verify Linda's story. Not the police officers who had questioned them on the beach, not the man whose door she had knocked on, not the couple near the Malibu feed bin, nor any of the drivers who had given them rides. They did find Saladin Nader, the Lebanese actor who had picked up Linda and another family member named Sandy while hitchhiking. But this was only partial corroboration, as Nader hadn't encountered the murder party on the night of the LaBianca killings. Meanwhile, the legal proceedings inched forward. When Manson filed an affidavit of prejudice against Judge William Keene, the case was reassigned to Judge Charles H. Older, a 52-year-old no-nonsense jurist and former World War II fighter pilot who had served with the Flying Tigers. This would be his biggest case to date. The trial date was set for June 15, 1970. As spring turned to summer in Los Angeles, Bugliosi's mind was heavy with concerns. The retrial of Bobby Beausoleil for the Hinman murder had concluded with a death penalty verdict. But during that trial, Mary Brunner, the first member of the Manson family, had done everything she could to absolve Manson while testifying against Beausoleil. Buliosi couldn't help but wonder, how far would Sadie, Katie, and Leslie go to save Charlie? And would Danny DiCarlo, whose testimony was crucial, but who had been hedging on many of his previous statements to police, stick around for the trial? In April 1970, the grand jury brought additional indictments against Charles Manson, Susan Atkins, and Bruce Davis for the Hinman murder. But as soon as these indictments were made public, Davis, who had been living with the family at Spahn Ranch, vanished. As the trial date approached, Bugliosi knew he had built a case on circumstantial evidence, calculated gambles, and the testimony of witnesses with questionable backgrounds and motivations. But sometimes, that's all a prosecutor has. The bloody words on the walls, the rope, the guns, the eyeglasses, and the damning statements of family members would have to be enough to convince 12 jurors that Charles Manson and his followers had committed some of the most shocking murders in American history. While prosecutor Vincent Bugliosi was building his case piece by meticulous piece, something sinister was brewing beneath the surface, a storm that threatened to upend everything. It was May 1970, nearly a year after the shocking Tate LaBianca murders that had paralyzed Los Angeles with fear. As the trial date approached, disturbing rumors began circulating through the parched desert communities surrounding Death Valley. Paul Watkins and Brooks Poston, two former Manson family members who had escaped Charlie's grip, were in the tiny town of Shoshone when they encountered some familiar faces: Clem, Gypsy, and a newer family member named Kevin. The message they delivered was chilling in its simplicity. Charlie says that when he gets out, you all had better not be around the desert. Not if he gets out, when. This wasn't just bravado. Sources at Spahn Ranch reported that family members appeared to be preparing for some activity. The Manson girls, now on a first-name basis with many reporters after countless interviews, repeatedly implied Charlie would be out soon. Tellingly, they never mentioned anything about him being acquitted or released. Something was being planned, but what? Let's take a quick break. Meanwhile, the prosecutor's carefully constructed case was showing cracks. On May 11th, Susan Atkins, known as Sadie Mae Glutz in the family, filed a declaration repudiating her grand jury testimony. This was the testimony that had been so crucial in breaking the case open, the testimony that had implicated Manson and detailed the horrific murders. Both Manson and Atkins used this declaration as the basis for habeas corpus motions, legal requests for release from unlawful imprisonment. Though these were denied, the damage to the prosecution's star witness was done. Buliosi and co-counsel Aaron Stovitz met with District Attorney Yvel Younger to discuss the implications. Atkins couldn't have it both ways. Either she had told the complete truth before the grand jury, in which case they wouldn't seek a first-degree murder conviction against her, or she had lied, in which case their agreement was breached. Buliosi believed Atkins had testified substantially truthfully before the grand jury, with three significant exceptions. She'd omitted the 3 additional murder attempts on the second night, she'd hedged on whether she had stabbed Wojtek Frykowski, which she had admitted to Buliosi in an interview, and Buliosi had a strong feeling corroborated by her confessions to fellow inmates Virginia Graham and Ronnie Howard that she had lied when she claimed she hadn't stabbed Sharon Tate. But under Atkins' agreement with the district attorney's office, substantially wasn't good enough. She had to tell the complete truth. With her declaration repudiating her testimony, the issue was settled. Buliosi and Stovitz asked Younger for permission to seek the death penalty against Susan Atkins along with the other defendants. He granted it. While Atkins' betrayal wasn't entirely unexpected, another development caught nearly everyone off guard. Bobby Beausoleil, recently convicted and sentenced to death for the murder of Gary Hinman, appeared in court petitioning for a new trial. He produced an affidavit signed by Mary Brunner, the first member of the Manson family and mother of Charlie's son, stating that her testimony in Beausoleil's trial was not true, and that she had lied when she said Beausoleil stabbed Hinman to death. The prosecutor in that case, Burton Katz, was visibly stunned, but argued that other evidence was sufficient for conviction. Upon further investigation, Katz discovered that just days before she was due to testify, Mary Brunner had been visited by family members Lynette "Squeaky" Fromm and Brenda McCann at her parents' home in Wisconsin. Squeaky visited again, this time with Sandra Good, 2 days before Brunner signed the affidavit. Katz charged that the women, representing Manson, had coerced Brunner into repudiating her testimony. What followed was a dizzying series of reversals that perfectly illustrates the disorienting effect Manson still held over his followers, even from behind bars. Called to the stand, Mary Brunner first denied being coerced, then, after speaking with her attorney, repudiated her repudiation, claiming her trial testimony was true after all. But she wasn't done yet. Later, she reversed herself again. The judge ultimately denied Beausoleil's motion for a new trial, sending him to San Quentin's death row to await his appeal. But the district attorney's office was left with a perplexing legal dilemma. After her testimony in the Beausoleil trial, the court had granted Mary Brunner complete immunity for her part in the Hinman murder. Except for possible perjury charges, it appeared Mary Brunner had managed to beat the rap entirely. As if the prosecution didn't have enough problems, the specter of legal delays loomed ever larger. Indicted for the Hinman murder, Manson appeared before Judge Raymond Dell to request that he be allowed to represent himself. When Dell denied the motion, Manson requested that Irving Kanarek and Day Shin be appointed as his attorneys. Judge Dell quickly identified a problem. Shin already represented Susan Atkins, creating a clear conflict of interest. This left Kanarek, a defense attorney whose reputation for obstructionist tactics was legendary in Los Angeles courtrooms. With remarkable candor, Manson told Judge Dell, "I do not wish to hire this man as my attorney, but you leave me no alternative. I understand what I am doing. Believe me, I understand what I am doing. This is the worst man in town I could pick, and you are pushing him on me." Manson then offered a deal. If Dell would permit him to represent himself, he would forget about having Kanarek. The judge wasn't having it. "I am not going to be blackmailed," he told Manson. "Then I will take it up to the bigger father," Manson replied, indicating he would appeal the decision. Behind the scenes, Buliosi and Stovitz discussed the possible Kanarek substitution with District Attorney Younger. Kanarek's reputation was such that with him on the case, the trial might easily stretch to 2 years or more. Younger asked if there was any legal basis for removing an attorney from a case. There wasn't, but Buliosi agreed to research the law and prepare an argument stressing Kanarek's incompetency. However, Buliosi didn't believe Kanarek was incompetent. His obstructionism was the real issue, and evidence of that was abundant. From judges to prosecutors to jurors, Buliosi collected examples of Kanarek's dilatory tactics. One deputy district attorney, upon learning he would have to oppose Kanarek a second time, quit the office entirely, saying life was simply too short. Anticipating that Manson would request Kanarek for the Tate LaBianca case as well as Hinman, Buliosi began preparing his argument. But a more elegant solution occurred to him. Perhaps, with the right bait, he could persuade Manson to dump Kanarek himself. Throughout my research in this case, there have been moments that have left me shaking my head and asking, how the hell could that happen? The gun found by 10-year-old Stephen Weiss, the bloody clothes found by a TV reporter lying in plain sight down an embankment, William Garretson, and the glasses. But this next story blew my mind. This moment perfectly encapsulates the maddening challenges Buliosi faced throughout the case. On May 25, 1970, while going through LAPD's evidence files on the LaBianca case, Buliosi noticed something standing against the wall, a wooden door with a multicolored mural. Buliosi was absolutely stunned. It's hard to imagine the shock he felt when he saw what was standing right in front of him. On the door were written lines from a nursery rhyme, 1, 2, 3, 4, 5, 6, 7, all good children go to heaven. followed by, in large letters, the words, "Helter Skelter is coming down fast." Buliosi froze, staring at the door. So in the evidence room of the La Bianca murder case, where, as you should know by now, the words Helter Skelter were written in blood on the refrigerator door at Waverly Drive, was a door with the words Helter Skelter written on it. On both occasions, they were spelled wrong. This time, Skelter was wrongly spelled with a C instead of a K. "Where in the hell did you get that?" Buliosi asked Detective Gutierrez. "Spawn Ranch." Bugliosi's mind was spinning. "When?" he asked. After checking the property envelope affixed to the door, November 25th, 1969. Bugliosi was stunned. "You mean for 5 months? While I've been desperately trying to link the killers with Helter Skelter, you've had this door with those very words on it, the same bloody words that were found at the La Bianca residence?" Gutierrez admitted they had. The door had been found on a cabinet in Juan Flynn's trailer at Spawn Ranch. It had been considered so unimportant that no one had even bothered to officially book it into evidence. What nobody realized at the time was that although 1, 2, 3, 4, 5, 6, 7, All Good Children Go to Heaven was a nursery rhyme, it was also on a Beatles track called You Never Give Me Your Money from the Abbey Road album, which was released on September 26, 1969. So the implication there would be it had to be written between then and November 25th. There wasn't many, if any, people outside the family and law enforcement that knew Beatles lyrics had been written in blood on a door at the murder scene at that time. So to find this at Spawn Ranch was incredible. What is even more incredible is that this was the La Bianca evidence room. How many La Bianca detectives had been in and out of that room perhaps multiple times? Had they also been at the scene of the murders where they must have seen the words Helter Skelter written on the refrigerator door? For anyone who has followed complex criminal investigations, this moment crystallizes a frustrating truth. Sometimes, the most critical pieces of evidence aren't hidden away in clever hiding spots. They're sitting in plain sight, overlooked by investigators who should know better. For months, Buliosi had been building his Helter Skelter theory of the case, the idea that Manson had ordered these killings to trigger an apocalyptic race war he called Helter Skelter, after the Beatles song. And here was direct evidence connecting that phrase to the family, painted on a door from their ranch. Let's take a quick break while we try to get our head around that one. Again, as he had numerous times before, Buliosi told the detectives he wanted to interview Juan Flynn, the Panamanian cowboy who lived at Spawn Ranch. Flynn had been interviewed for a quickie paperback book published before the trial began, alongside former family members Brooks Poston and Paul Watkins. But Flynn had obviously held back a great deal of information, as many incidents Buliosi had learned about from Brooks and Paul weren't included. What did Juan Flynn know, and why had he been so reluctant to share it? As the trial date approached, the warning signs were impossible to ignore. The family appeared to be mobilizing for something. Former members who had cooperated with authorities were being threatened. Key witnesses were recanting their testimony, and Charlie was maneuvering to either represent himself or be represented by an attorney known for dragging out trials for years. Meanwhile, crucial evidence connecting Manson's Helter Skelter philosophy to the murders had been sitting ignored for months. Perhaps most disturbing was the confidence emanating from the remaining family members, the absolute certainty that Charlie would soon be free. Not acquitted, not released, just out. What did they know that the authorities didn't? What were they planning? And how far would they go to free their leader? By June 1970, the pieces were in place for what promised to be an extraordinary trial. Prosecutor Vincent Bugliosi had meticulously built his case against Charles Manson and his followers for the brutal murders of Sharon Tate and 6 others. But Manson, ever the master manipulator, had one more card to play. Just 2 weeks before the trial was set to begin, Manson requested a substitution of attorneys. He wanted to replace Ronald Hughes with Irving Kanarek. This might seem like a mundane legal procedure, but Buliosi immediately recognized it as the tactical maneuver it was. Alarmed, Buliosi requested an urgent conference in the judge's chambers. There he delivered a stark warning to Judge Charles Older. "It is my frank opinion," Buliosi told the judge, "that if Mr. Kanarek is permitted to represent Mr. Manson, the case could last several years." He didn't mince words, calling Kanarek a professional obstructionist and warning that even the threat of contempt charges wouldn't deter him. Kanarek would gladly spend the night in jail rather than modify his disruptive behavior. What makes this particularly fascinating is that Buliosi didn't just complain about the situation. He offered a surprising solution, one that stunned everyone in the room, including Manson himself. As a possible solution, Buliosi proposed, the prosecution has no objection to permitting Mr. Manson to represent himself as he has desired throughout, and let him have an attorney of his choice to assist him. Think about that for a moment. The lead prosecutor in this high-profile murder case was actually suggesting that the defendant, a man he believed had orchestrated 7 brutal murders, be allowed to represent himself. Why would Buliosi make such a risky proposal? The answer reveals Bugliosi's strategic thinking. He knew that Manson had insisted from the beginning that only he could speak for himself. Buliosi also recognized that Manson was highly intelligent despite his lack of formal education. Having dominated his followers for years, Manson might actually be more effective at cross-examining former family members than a traditional attorney. Moreover, Bugliosi was looking ahead to potential appeals. Denying Manson's request to defend himself could later become grounds for overturning any conviction. But the most telling reason? Bugliosi understood that Manson had chosen Kanarek specifically to create chaos and delay. It was a deliberate attempt to undermine the entire judicial process. Judge Older himself acknowledged the problem, telling Kanarek, "As a matter of common knowledge among the judges in this court, there's a good deal of truth in what they say. I am not impugning your personal motives, but you do have a reputation for taking an inordinately long time to do what someone else can do in a much shorter period." Manson, with characteristic manipulation, admitted as much himself. When asked if Kanarek would be the best attorney for him, Manson replied, "In a lot of respects, he would be the worst attorney that I could take." Then came the threat, barely veiled. "I am forced into a situation," Manson told the judge. "My second alternative is to cause you as much trouble as possible." Judge Older denied Bugliosi's motion to prevent Kanarek from representing Manson. Despite the prosecution's effort to save taxpayers perhaps several $1,000,000 and everyone involved a great deal of time and unnecessary effort, Irving Kanarek would remain as Manson's attorney for as long as Manson wanted him. It wouldn't take long to see the consequences of that decision. On June 9th, just days before the trial was set to begin, Manson made his move. In an act of calculated defiance, he suddenly turned his chair around, physically turning his back to the judge. "The court has shown me no respect," Manson declared, "so I'm going to show the court the same thing." After several warnings, Judge Older had no choice but to have Manson removed from the courtroom. He was taken to an adjoining lockup equipped with speakers so he could hear the proceedings, though not participate. But this was just the beginning. The next day, Susan Atkins stood up and announced, "If Your Honor does not respect Mr. Manson's rights, you need not respect mine." She too turned her back to the judge. Leslie Van Houten and Patricia Krenwinkel immediately followed suit. When Judge Older suggested the defense attorneys speak with their clients, Paul Fitzgerald admitted it would do little good, because there is a minimum of client control in this case. After warnings, the 3 women were also removed from the courtroom. For Bugliosi, this spectacle created a dilemma. On one hand, the women's behavior demonstrated Manson's control over them, useful evidence for the prosecution's case. On the other hand, removing defendants from the courtroom might constitute grounds for appeal later. The following day brought even more theater. When all 4 defendants were brought back to court, Judge Older warned them that their conduct could jeopardize their cases if they continued in front of a jury. Manson's response was pure theater. "Okay, then you leave me nothing," he said dramatically. "You can kill me now." Then, in a moment that must have been surreal for everyone present, Manson bowed his head and stretched out his arms in a crucifixion pose. The three women immediately mimicked him. When deputies tried to seat them, a scuffle broke out, with Manson ending up on the floor, wrestling with a deputy before being carried bodily to the lockup. But here's where the mask slipped. Once out of sight of the press and spectators, Manson transformed. The rebellious cult leader became the compliant prisoner. Having spent more than half his life in institutions, he knew exactly how to play by the rules when it suited him. As Buliosi noted, he was thoroughly institutionalized and rarely caused trouble in the jail itself. The performance was just that, a performance designed for maximum effect and disruption in the courtroom. If Manson's theatrics weren't enough, Kennerek quickly demonstrated why Buliosi had been so concerned about his involvement. During arguments on a search and seizure motion, Kennerek accused Buliosi of conspiracy and suborning perjury, extremely serious allegations to make publicly without evidence. Buliosi's reaction was immediate. "Your Honor, if Mr. Kennerek is going to have diarrhea of the mouth, I think he should make an offer of proof back in chambers. This man is totally irresponsible." But the most bizarre moment came when Kennerek argued that since the warrant of arrest for the defendant Manson was based on illegally obtained and perjured testimony, therefore the seizure of the person of Mr. Manson was illegal. His solution? The person of Mr. Manson must therefore be suppressed from evidence. Yes, you heard that correctly. Kennerek wasn't trying to suppress evidence found on Manson or in his possession. He was trying to have Manson himself suppressed as evidence. As Buliosi put it, Kennerek was arguing that that piece of physical evidence, which is Mr. Manson's physical body, should not be before the court conceptually to be used in evidence. Even the other defense attorneys looked stunned. Judge Older denied the motion. Behind all this courtroom drama, Buliosi continued his diligent preparation for trial. In early June, he interviewed a crucial witness, 16-year-old Diane Lake, a former Manson family member who had been institutionalized at Patton State Hospital. The transformation in Diane was remarkable. The little ragamuffin Buliosi had first met in jail now looked like any other teenager. She was getting straight A's in school and told him that not until getting away from the family had she realized how good life could be. Looking back, she felt she had been in what she called a pit of death. Diane provided critical new information. She revealed that Patricia Krenwinkel had admitted dragging Abigail Folger from the bedroom into the living room during the Tate murders. Leslie Van Houten had confessed to Diane that she had been reluctant to stab someone at first, but then discovered that the more you stabbed, the more fun it was. Most importantly, Diane told Buliosi that in the months before the murders, Manson had repeatedly told his followers, "We have to be willing to kill pigs in order to help the black man start Helter Skelter." About a month before the murders, he had declared, "I'm going to have to start the revolution." But perhaps the most heartbreaking thing Diane shared was about the women in the family. They could never love anyone else, she said, not even their parents. When Buliosi asked why not, Diane's answer was devastating in its simplicity. Because they've given all their love to Charlie. As the preliminaries wrapped up on June 12, 1970, Judge Older recessed court for the weekend. The stage was set for the trial to begin the following Monday, June 15, 1970. What would happen when the actual trial began? Would Manson and his followers continue their disruptive tactics? Could Buliosi overcome the deliberate obstruction to present his case effectively? And how would all this theater impact the jury's perception of the defendants? The answers to these questions would unfold in what would become one of the most extraordinary trials in American legal history. That's all for this episode of our Charles Manson story. In the next episode, we'll delve into the opening days of the trial itself, as Buliosi begins to present his case against Manson and his followers. After this quick break, we'll hear what our crime experts think of all these legal maneuvers.
Tom, another great episode 20, and we're coming right up close to the trial now. But I was interested what Alex dug out about this performance comment that Charlie is actually in performance mode now, isn't he, in the court? And he's a different person in custody because he'd spent half his life in custody, so he knew how to behave in these institutions. But when he was let free in front of the judge and the court, he really was just putting on a performance. Things like, you can kill me now, and standing as if it's a crucifixion. He's just playing to the crowd. And the whole idea of his lawyers sacking and recruiting strange lawyers all over the place.
I agree, Simon. It's a fascinating episode, this, and his conduct in the court. It reminds me very much of the Manuel murders. Peter Manuel, we've done an episode about Peter Manuel. This performance in the court of sacking his defence, of nobody can defend anyone like me. This ego, this massive ego, the alter ego of I'm Jesus Christ here on earth. I'm being punished. Yeah, very, very, very interesting profile of him. The other thing that struck me about this episode was this business about the door from Spawn Ranch, which had been taken as evidence, and which has got Helter Skelter written on it, and is sitting in an evidence room, and Buliosi comes across it by accident.
Yeah.
But I've got a question here. You see, Buliosi is fantastic, and he's the hero of the story. He's done a wonderful job making up for a lot of not so wonderful work, frankly, by our ex-American law enforcement colleagues. But this business that the door is in this production cupboard and nobody has put two and two together indicates to me a complete lack of unity of thinking and a very poor briefing.
Yeah.
See, Buliosi has been asking law enforcement officers to do certain things. I want you to do that and you do that. Some of them have done them, some of them haven't. But has he ever shared the big picture with law enforcement officers? And perhaps there's a reason for that. Perhaps it's because he didn't trust them. I don't know. But I think it's a question I'd like to ask Alex, because this just strikes me. When Helter Skelter appears at a crime scene and is so critical to the whole case, and yet law enforcement officers don't realise it to the extent they're walking past a door from Spawn Ranch in the production cupboard with that written on it, something's wrong.
Yeah, 5 months later.
Something is wrong. And I just wondered what the briefing process was. Did Buliosi have the confidence to take his senior detectives all into one room, the LAPD, the LA County, the different sheriff's department? Listen, guys, here's the plan. This is what we're trying to do. I wondered, did that ever happen? If it didn't, then it leaves us vulnerable to this kind of mistake being made.
Even a brainstorming session, Tom, I remember having them on murder inquiries regularly, where the boss would say, bring up whatever's in your mind that you're not sure about, or you want to question or want to think about, anything at all. And for a couple of hours, we would all sit round drinking coffee and just talking about the whole thing. And we would have the scenes of crime photographs. That struck me. The photographs from Spawn Ranch, the photographs from the murder loci would have been on the table. These things would have become obvious with proper communication and management.
Yeah, and it also acts as a pressure valve as well. We are about to see the start of a public inquiry in Scotland into the case of Emma Caldwell, the sex worker who was murdered in 2005. There were clearly detectives on that squad who had strong views about suspects that the hierarchy did not, and the hierarchy dismissed these thoughts. The fact that has been bottled up, and the fact that has never been allowed to come out in the open and be argued out in that kind of, the kind of session you're talking about, you're absolutely right. You say, listen, boss, what about such and such? Okay, I tell you what, let's take this. Come on, okay, we don't fancy him, but let's have him. Put him on the wall. What have you got? What have you got? What have you got? And let everybody, at least people would then feel that they'd had their say.
Yes.
Yeah? Whereas the whole of the Emma Caldwell thing is about people who felt they did not have their say, their voices were drowned out or shouted down, and consequently, they were found to be right.
I had a boss who used to say, if you convinced him enough, he would say, tell you what, McLean, take someone with you and follow that till you're happy. Go and do it. And off I would go.
It's a strange word to use, happy, but it's right, because if you have got people on your squad who are discontented and who don't believe the way the inquiry is going is right and are niggling away, in other words, you've got a disruption in the squad. And you just cannot have that if you want to succeed.
Yeah. And one of the dangers of any squad or team put together for a specific purpose is that some people can dominate the conversation. Some people speak over other people. And there's some of us, like myself, obviously, who are that bit more reticent to speak up, and we might never be heard. So that kind of meeting gives everybody a chance. The boss would actually say, Simon, what do you think? And give you a chance to speak without the two or three that might dominate the conversation doing so. Does that make sense to you?
It does, Simon, and I kind of say your shyness is one of your major failings, we've got to say. I hope that, and my hope was that during the course of Crime Time Inc., it would act as a sort of a therapy, where, I would encourage you to, be more forthright. Be more forthright. It's good. And you're doing well, Simon. You're doing well.
Tom, I meant to say to you in our previous dissection of episode 19, there was a bit of it that I meant to speak to you about and we forgot about it. And I just thought I'd bring it up here, the gunshot, because I know that you've got a particular interest in firearms, ballistics, etc. Mm-hmm. And it was the shooting of Bernard Crowe and the bullet still being in him. Do you not think they should just have done a biopsy to get the evidence? It's the best evidence rule, isn't it?
Yeah, it is the best evidence rule, but sometimes the reason a bullet is left in someone is only ever because to remove it is endangering life. Sometimes bullets and shotgun pellets are lodged in a place where the risk of taking them out is greater than the risk of leaving them. Of course, the risk of leaving them is always infection.
Yes. It was interesting, that bullet, it could have proved that it was the same gun as the weapon at the Tate murders.
No, but the forensic examiners made a very good point, that actually the natural acids in the body would almost certainly have corroded slightly the bullet, so as in all likelihood remove the striation marks from it, because your body's a very hostile environment and the natural acids will degrade it over time. So I think on balance that was a fair decision.
Yeah. I thought the comment about Bernard Crowe, he was asked if he would submit to the operation to remove this bullet, but he was told of the risks involved and he declined the operation. He said, no, having the bullet inside me is a great way of meeting people and getting conversations going. Typical drug dealer.
Picture the scene. You're a drug dealer, okay, and you get an offer from law enforcement to have invasive surgery to have a bullet removed. You're going to be thinking, hang on a minute, could be a downside here, could there not? I think I would have said the same thing.
I think so. Tom, back to episode 20 again. We're kind of on a knife edge now, and the antics of Manson. Now the worry is that this trial is going to become just a farce because the solicitors that he's getting involved, this solicitor who just tries to make a mockery of the court, he wants to defend himself and he's been refused the right to do that. The important part of this is that you would think that he's building up to give himself lots of room for appeal afterwards. The more you make the court go against you, the more things you've got to bring up on appeal if he's ever found guilty.
I was actually very pleased to hear that in the American justice system they had obstructionist lawyers like Mr. Kanarak, because I thought we were the only people that had them. I've known a number of these people and they appear to be plodding and they appear to be not very well with it. But yet actually their tactic is just to sow confusion and just play it so long that the procurator fiscal gives up and accepts a plea. I think that was all about giving him the maximum platform time. It's all about the ego. It's all about Manson's ego and wanting to be centre stage and wanting to be on the stage for as long as possible and wanting to show himself this monstrous ego he had, which drove the whole thing, of course, ultimately. Yeah. I think choosing someone like Kanarak, he knows that he'll have time to be in the court and be that centre of attention that he wanted to be. That's what it's all about.
Yeah. I think I've told you before, Tom, that when I gave evidence, especially a sheriff and jury or a high court trial, I always gave my evidence to the bench. Not just to annoy the defence counsel, but for my own benefit too. So often, and you'll know what I'm talking about here, what they're trying to do is confuse the jury. So you finish your evidence, as you know, the Crown take you through, or the Fiscal takes you through your evidence in chronological order, and everything's clear. The purpose is to be clear, the timeline, the important parts of it, identification, productions, pointing out the accused if that's relevant, the charge procedure, all of that is chronological and it's nice and clear for the jury. And the defence lawyer's job is to confuse that in the eyes of the jury. So he starts asking questions out of sequence, and some of them are just nonsense that don't make any sense. And I've seen it many times where I've got that confused look in my face because I'm not sure where he's asking it, but I'm looking at the sheriff or the judge. And the judge has got confused because he's writing everything down, of course. And when he gets to the point where it's becoming farcical or he's got to his point, very often, and this really was very often, especially with certain sheriffs that I gave evidence in front of, the sheriff would say to me, "Officer, is this the case?" Yeah. And he would summarise my evidence, Tom, in about 2 or 3 paragraphs. And of course, at the end of it, I would say, "That's exactly the case, Your Honour." And he would say, "Right, let's move on."
And that's it. But in a real sense, Simon, you're giving evidence to the court, and the court is represented by the sheriff or the judge. Yeah. So you're absolutely right to be giving evidence to the judge in reply to the judge. But it's a great technique because you know that you've got the sheriff on your side.
Yeah, and it really winds the defence counsel up as well. Tom, we're ready for trial to start now. We've gone through all Charlie's carry on in the court and we've no idea who's going to speak to what with these girls. They're starting to show a loyalty to him now as well, aren't they? That's the fascinating feature of this whole thing, is the family dynamic. And it seems to be going on still at the commune, at the ranch, etc. That family feeling still seems to be there. I'm thinking here where all the women turned round, as Charlie did, and turned his back on the bench. And they all did the same. And they all get sent out of the court. There's a real power there from Manson, isn't there?
There absolutely is. And it seems to extend over time and distance. So we know that over a long passage of time, even though the girls are hundreds of miles away and have apparently fled and have apparently reached safety, that they still have this loyalty. And I think that's the power of the cult. And that's the power that he exudes. And later, perhaps we'll talk about that because, of course, Charles Manson is not the only example of a cult leader who can manipulate and maneuver people into doing the most incredible thing. I mean, the Jonestown Massacre, we've discussed that briefly in previous episodes, is a classic example, but there are many others. You might say that...
we called them superintendents.
Yeah. Adolf Hitler was a cult leader in a very true sense in the mid to late 1930s. He captured the mindset and the beliefs of people who started acting in a way and thinking a way and doing things which they would never have done, But they were captivated by this. This whole
Great stuff, Tom. We're on to June the 15th, the start of the trial, 1970. I can't wait to hear it next week.
I'm looking forward to it. Alex, first-class job once again, and we're waiting with bated breath.